Chapter 22, Rape. Section 425. Definition. Rape consists in the act of having carnal knowledge, by a man, of a woman other than his wife, forcibly and against her will, or without her conscious permission, or where her permission has been extorted by force or fear of immediate bodily injury. Among other definitions by standard authorities are the following: rape is the unlawful carnal knowledge of a woman by force and against her will. Rape is when a man hath carnal knowledge of a woman by force and against her will. Rape is the carnal knowledge of any woman above the age of 10 years against her will, and of a woman child under the age of 10 years with or against her will. It seems that rape is an offense in having unlawful and carnal knowledge of a woman by force and against her will. Rape is the carnal knowledge of a woman forcibly and against her will. Rape has been defined to be the having unlawful and carnal knowledge of a woman by force and against her will. Rape is the having of unlawful carnal knowledge, by a man of a woman, forcibly and against her will. Section 426. Against her will. Without her consent. It has been suggested that the phrases against her will and without her consent are to be distinguished. The question is, what is the real definition of the crime of rape, whether it is the ravishing of a woman against her will, or without her consent? If the former is the correct definition, the crime is not in this case proved. If the latter, it is proved. It is to be observed, however, that this view, which has given rise to confusion upon this subject, is erroneous. The phrases are synonymous. Section 427. Scope of the resistance. Must the woman resist to the uttermost? Upon this question the authorities are not harmonious. Many of the decisions hold that she must use all the resistance in her power under the circumstances up to the time of the intercourse, that is, until exhausted or overpowered. On the other hand, it has been held that there was no rule of law requiring a jury to be satisfied that the woman, according to their measure of her strength, used all the physical force in opposition of which she was capable, and that it is enough that by word and act she showed her unwillingness. Section 428. Consent induced by fraud. Upon this question, also, the authorities are not harmonious. By the weight of authority, however, when the woman understands the nature of the act, and her consent is obtained by fraud, the offense is not rape. Section 429. Fraudulently represents marriage ceremony legal. When a man fraudulently represents to a woman that an illegal marriage to her is legal, and has carnal knowledge of her, induced by her belief in his fraudulent misrepresentation, he is not guilty of rape. Section 430. Man fraudulently personates the woman's husband. At common law, when a man fraudulently personates a woman's husband and thereby has carnal knowledge of her, he is not guilty of rape, and it is held that fraud and stratagem cannot be substituted for force, as an element of this offense. On the other hand, there are decisions which hold the contrary view. Thus, in a leading Irish case, where a man personated a woman's husband and thereby had connection with her, he was held guilty of rape. In England, and in a few of the states of this country, statutes have been passed which make having carnal knowledge of a woman by falsely personating her husband rape. Section 431. Woman insane or idiotic. When a woman is insane or idiotic, and does not know the nature of the act, carnal knowledge of her by a man other than her husband, who is charged with knowledge of her mental condition, constitutes rape. If, however, she consents from passion, morbid desires or animal instincts, the offense is not rape. Nor is it rape when the man does not know that the woman is incapable of giving consent and uses no actual force to compel her to submit to the act. The mere fact that a woman is weak-minded does not show incapacity to give consent. A woman who lacks mental capacity to make a contract may have capacity to consent to sexual intercourse. But when a man has sexual intercourse with a woman, other than his wife, of such weak and disordered mind that she cannot understand the nature and consequence of such act, he is guilty of rape. There must be, however, some evidence that the act was without her consent. But when she is incapable of expressing any intelligent assent or dissent, or of exercising any judgment in the matter, the offense is rape, though no more force be used than is necessary to accomplish the carnal act, and though the woman offer no resistance. Section 432. Cleavenger's view. Cleavenger, in his work on medical jurisprudence of insanity, gives the following comprehensive statement of the law upon this subject as applied by the American courts. Sexual intercourse with a woman who is so destitute of mind as to be incapable of giving consent is rape, though she does not resist. The test of mental capacity under this rule is whether she was capable or incapable of giving consent or of exercising any judgment in the matter. And very slight proof of force is necessary where the woman lacks the intelligence to comprehend the nature and consequences of the act, and to distinguish morally and legally between right and wrong. And when the man does not suppose that he has her consent, the force required and which is involved in the carnal act is sufficient. But where the will is active, though perverted, the act is not rape, when all idea of force or unwillingness is distinctly disproved. And the mere fact that a woman is weak-minded does not disable or debar her from giving consent to the act and intercourse with her when she is capable of exercising her will sufficiently to control her personal actions is not rape. And if there is reasonable doubt whether force was used, the jury should acquit though the woman was of weak mind. A woman with less intelligence than is requisite to make a contract may consent to sexual intercourse so that the act will not be rape upon the part of the man. And connection with a woman who is in a state of dementia, and not idiotic, but approaching toward it, having a predisposition to be with men and a morbid desire for sexual intercourse, is not rape when no circumstances of either force or fraud accompany the act, nor is intercourse without resistance with a woman subject to epileptic fits, where the evidence does not show that she was under the influence of a fit at the time, the burden of proof of insanity at the time of the act, and that the carnal knowledge was obtained by force and without consent, rests with the prosecution. There must be some evidence that she was incapable, from imbecility, of expressing assent or dissent. And when consent is given from mere animal passion or instinct, it is not rape, and a conviction cannot be sustained in the absence of evidence as to her general character for chastity and decency, or anything else to raise a presumption that she did not consent. Evidence of the connection and the imbecility alone is insufficient. But evidence of habits of decency raises a presumption that she would not have consented. The foregoing statement constitutes an epitome of the English and American decisions upon the questions involved. Section 433. Woman sane but insensible. When a woman is reduced to a state of insensibility by the use of drugs or intoxicating liquors, sexual intercourse with her while in such condition, by a man other than her husband, constitutes rape, and whether her insensible condition has been produced by the man or not is immaterial. This is the modern English rule as well as the American rule. Section 434. Woman asleep. The rule applicable to the case where the woman is senselessly drunk is also applicable where she is asleep. If she is asleep at the time of the act, so as to be unconscious of it, it is done without her consent and constitutes rape. Section 435. Consent induced by intimidation. It has frequently been said that force is a necessary element in the crime of rape. 31. It is to be observed, however, that it may be constructive as well as actual, and furthermore, that fear may take its place. If, at the time a man has carnal knowledge of a woman, her mind is so overpowered by fear induced by him as to cause her to make no resistance, the offense is rape. Where the woman is paralyzed from fear and terrified into submission, her consent to the act is void. The law does not require the doing of impossible or useless acts. A reasonable apprehension of death, however, is not essential. Fear of grievous bodily harm is sufficient. An acquiescence obtained by duress, or fear of personal violence, will avail nothing. The law regarding such submission as no consent at all. If the mind of the woman is overpowered by a display of physical force, through threats, expressed or implied, or otherwise, or she ceases resistance through fear of great harm, the consummation of unlawful intercourse by the man would be rape. Section 436. Carnal knowledge of a child. Carnal knowledge of a child, however young, with her consent, was not rape under the English common law. The first statute of Westminster, passed in 1275, made the carnal knowledge of the child within age, 12 years, even with her consent, a misdemeanor. The second statute of Westminster, passed 10 years later, made rape a felony, but it was silent as to the age of the victim. The statute of 18 Elizabeth, passed some 3 centuries later, made the carnal knowledge of a child under 10 years of age, with her consent, a felony. This statute, however, did not describe the felony as rape. All of these statutes form part of our American common law, and under this law the courts hold that carnal knowledge of a child under 10 years of age, even with her consent, constitutes a felony. In this country statutes have been passed raising the age of consent, and making the crime rape within the age fixed, even when the child consents to the act. Under these statutes the age of consent varies greatly in the different states, in a few reaching as high as 18 years, in Illinois it is 16 years, in many of them it is 14 years. Ignorance of the accused as to the victim's age, and a bona fide belief on his part that she was above the age of consent at the time of the act, constitute no defense. The prosecution has the burden of showing, beyond a reasonable doubt, that the child was within the age of consent at the time of the act. Testimony as to the child's age at the time of the act may be given by herself, or by members of her family, but declarations by her to others upon this point are inadmissible. Medical expert opinion evidence is admissible, and it is always proper for the jury to take into consideration the appearance of the child. Whether the child was within the age of consent or not is a fact for the jury to decide. But when the accused admits that she was, the question need not be submitted to the jury. On the other hand, when the only evidence upon the point is that given by the child, the trial court errs in assuming that the fact is established. Some statutes make it essential to conviction that the child shall have been of previous chaste character. But under these statutes the defendant cannot take advantage of his own act in previously destroying her chastity. Section 437. Consent obtained by fraudulent representation of physician. When a medical practitioner falsely and fraudulently represents to a patient that coition is an essential part of the treatment in her case, and owing to her belief in the representation she consents to connection with him, he is not guilty of rape. The reason is she consents to the act. On the other hand, when a medical practitioner, under pretense of making a professional examination of her person, or of performing a surgical operation, has connection with her, and she is ignorant of the nature of the act, he is guilty of rape, and the reason is she does not consent to the act. Section 438. The act itself. Penetration, emission. Carnal knowledge of the person of the female is an essential element of rape, and to have carnal knowledge there must be penetration. The slightest penetration, however, is sufficient. The fact of penetration does not have to be shown by the prosecutrix herself, nor does it have to be established by direct evidence. Under the early common law, emission was not considered an essential element of rape. Later, however, it was expressly adjudged essential. The Statute of Geo. 4 provides that proof of emission is not necessary, and this rule obtains in England today. In this country a few courts have held that proof of emission is essential, but the great weight of authority is to the contrary. In some of the states, including New York and Michigan, statutes have been passed expressly providing that proof of emission is not essential, and in a few cases it has been held that emission is presumed from the fact of penetration. Section 439. Incapacity of male. Boy under 14. A male person who is impotent and incapable of copulation cannot commit rape. To be capable of committing this crime a man must have physical capacity to perform the act of carnal knowledge, and evidence which tends to show that the accused at the time of the alleged offense was in a greatly debilitated condition from a previous debauch is admissible and constitutes a circumstance, however light, to be considered by the jury in ascertaining whether he was physically capable or not of committing the offense. When, however, he is capable of penetration, though incapable of emission or procreation, he has capacity to commit rape. At the early common law, a boy under 14 years of age was conclusively presumed incapable of committing rape, and testimony tending to show capacity was inadmissible. This rule is followed by some of the courts of this country, and repudiated by others. Many courts hold that the presumption of incapacity is disputable, and testimony tending to show capacity, admissible. In Louisiana it has been held that even a disputable presumption of incapacity does not exist. Section 440. Criminal responsibility of husband or wives. A husband cannot commit rape on his wife by having carnal knowledge of her by force and against her will. Nor is a wife a competent witness against her husband in a prosecution against him for a rape committed on her prior to their marriage. But defendant's marriage to the woman after the offense is not a defense to a charge of rape. Ordinarily, however, A wife is a competent witness in a criminal prosecution against her husband whenever she is the person particularly indirectly injured or affected by the crime for which he is being prosecuted. Thus a wife is a competent witness against her husband in a criminal prosecution against him for incest. When a husband, however, aids or abets a third person to have carnal knowledge of the former's wife, forcibly and against her will, the husband is guilty of rape. If present at the time of the act he is a principal in the second degree, and if absent he is an accessory before the fact. And, upon the same principle, a woman may be guilty of rape when she aids or abets her husband, or any other man not the husband of the victim, to have carnal knowledge of another woman forcibly and against her will. Section 441. Chastity of the victim. In the case of seduction, chastity of the victim is an essential element of the offense. In the crime of rape, however, chastity of the victim is not an essential element. It has been held that in a prosecution for rape testimony of want of chastity in the prosecutrix is inadmissible. This, however, is not the better view, nor the weight of authority. The purpose of admitting it is to show that she probably consented to the act, or if under age of consent to show her credibility. Rape, however, can be committed on a common prostitute. But, in an early English case it was held that prior voluntary intercourse between the parties constituted a defense. This, however, is not the rule now.